the other way, there's certainly no provision in the multipartite agreements that's consistent with automatic termination, or even alludes to it. The second point, dealt with third in para 6 of the owner's skeleton, is reliance on the reference in the recitals to the multipartite agreements to the subcharter parties being on back-to-back terms. But again, we say that doesn't take matters any further forward, because each of the charters provides for termination by the respective owners exercising an option to terminate. So, keeping with our extracts of contractual clauses, page 137, clause 40, subparagraph 3, towards the foot of page 137, is the right to terminate. And in particular, the third line down, the owners may, at their option, and by notice in writing to the charterers, a termination notice, terminate this charter with immediate effect. So, the reference to the charters being back-to-back is in fact inconsistent with automatic termination, because when you look at the charters, their terms give an option to terminate, and anyway, we say these are only recitals, not the operative provisions, and therefore they are really of very little assistance in interpreting the multipartite agreements. And then the final point, 6.2 in my learned friend's skeleton, is reliance on clauses 37 and 38 of the charters, which are at page 136. As to that, clause 37 on 136 says, upon any termination of this charter which results in the return of the vessel to the owners, the clause which results in the return of the vessel to the owners shows that it's envisaged that there could be a termination which doesn't result in a return of the vessels. And that's reinforced by clause 40 sub clause 4 on page 138. On or at any time after termination, the owners shall be entitled, but not bound, and skipping to the next line, to retake possession of the vessel. So that provision isn't consistent with automatic termination, because it envisages that redelivery is a choice by the owners, which they may or may not exercise, depending on their interests. And going back to...
But it hardly contemplates different choices at different stages of the contractual chain, does it?
Well, each of these clauses is within its own charter, and so the choice would be made at each stage by the relevant owner. So that would be clearly the owners under the head charters, but then the charter is under the subcharter.
Well, maybe it goes more to your ground too, perhaps, but the scheme seems to be that the owners, head owners, will choose when there is a termination event, whether they want to terminate the charter or not. And if they do, they'll say we terminate and we demand redelivery of the vessel. And do you say then that the charterers can decide, well, we're not very interested in that, we're going to keep our subcharter going, thank you very much?
Well, in practice, there's a mechanism which might prevent them from doing that, which is the multipartite agreement. But the mechanism isn't, we say, automatic termination, that those rights to terminate essentially fall by the wayside at that point because the charter's already gone.
Yeah, okay, I see.
And the third relevant provision is clause 38, reference to free of any subcharter. That's on page 136, towards the bottom of the page, just before the last clause, quoted, the vessel shall be redelivered free of any subcharter. Well, in a sense, we say that just doesn't add anything, because a subcharter isn't an encumbrance. By definition, if the vessel is redelivered, it would be free of a subcharter, I suppose, so far as the relevant owner is concerned. So that doesn't actually tell you anything about automatic termination. So there's no, we say, justification in the language either of the multipartite agreements or the charters themselves for automatic termination. Everything actually points the other way, that the charters should be given effect in accordance with their terms, that they give options to terminate under each charter. The owners say there's no language supporting our case, but we would beg to differ. We would refer in particular to the provisions as to possession in each charter, an example of which can be seen on page 132. Towards the foot of page 132, clause 10A1, during the charter period, the vessel shall be in the full possession and at the absolute disposal for all purposes of the charterers. The charter period being the time until that particular charter is terminated. So that is consistent with the right to possession extending until the particular charter has been terminated, and it's not consistent with some concept of the right to possession being dependent on termination of the charter higher up the chain.
Yes.
As to whether there's a real prospect of another court reaching a different view from the judge himself said at paragraph 111 of the judgment that this was not by any means a straightforward point, which we would say supports our position that there's a real prospect that a different court could reach a different view.
Yes, I mean the judge evidently didn't equate that with real prospect of success on appeal, or he'd have given you permission.
Well, I see at that stage, I see the force. There are a number of points where the judge expresses views about how difficult the points are, or it's relatively tentative, and you say that, as it were, indicates the real merits of the arguments, whatever was said on the permission to appeal application. Turning then to ground 2, the obligation to terminate the subcharters and to redeliver the vessels under the multipartite agreements. As I've said, there are two aspects. The first being whether the owners were entitled under the multipartite agreements to instruct termination, even if compliance with those instructions would involve repudiating the relevant charters.
Now, how does that arise? Because ex hypothesi, there is a termination event under every charter party down the line.
Yes, so that arises where, although there's been a termination event, because of the delay in exercising the right to terminate, that right has been lost by way of either an implied term that it has to be exercised within a reasonable time or through election.
Right.
And that's not a debate that has figured greatly in the appeal documents, but essentially in the first instance proceedings and in the arbitration, there was a debate which neither the tribunal nor the court resolved as to whether there is in fact either an implied term in these charters that any right to terminate has to be exercised within a reasonable time, or alternatively any such right can be lost by election.
Yes, I mean, well, that's an old chestnut that's been hanging around for years,
yes.
And the answer to it very rarely, if ever, matters.
Yes, which is probably why it hasn't been decided. But no, but for these purposes, we can proceed on the basis that that's an arguable case, that the right is lost, or can be lost, through effluxion of time, or effluxion of time plus conduct, such as acceptance of hire under the relevant charter. And so if we're right on, then the question arises in relation to that question, and this is the second limb of the appeal: was the right lost? Was there were there circumstances which would have led to the right being lost, either on the basis of the implied term or through election?
the judge was against you on the facts there, paragraph 124.
Yes.
So
Well,
why does that give rise to an arguable point on appeal?
because we say the judge was focusing on the wrong facts and in relation to the wrong parties. Essentially, skipping over the first point here, but yeah, essentially the problem with the judge's reasoning in relation to the second question is that he was looking at it as if it was the position of the owners that was relevant and not the position of the charterers or the sub-charterers. And we've set out all the references for that at paragraphs 25 to 26 of our skeleton. But essentially, he treats the clock as ticking from September 2023, when the owners became entitled to terminate, rather than from, or at least when the owners knew that they were entitled to terminate, rather than from the 10th or the 14th of July 2023, which is when the charterers and the sub-charterers would have known they were entitled to terminate because they knew about the facts of the change of control. So that's the first problem. The second problem is that by focusing on the owner's state of mind and their desire to have the charters terminated and the vessels redelivered, he ignores the fact that the charterers and the sub-charterers had no wish to terminate the charters and have the vessels redelivered. And so, as against their respective charterers, it's the equivocality or not of their conduct which calls to be considered. And so, ultimately, there was no decision on the right factual question.
Yes, I see.
So going back to the first limb, and picking up the judgment of paragraph 120 on page 84, in the first line, in relation to that first question, the judge says the answer in the abstract is likely to be in the negative. So it, as an abstract question, the judge agreed with our proposition that you wouldn't expect a party to be entitled to direct another party to repudiate a contract. But he said it had to be seen against the background of the back-to-back nature of the charter parties. So that again was a reference back to the analysis that because these charters are back-to-back, essentially what goes for one goes for all.
I mean, they're not just back-to-back, are they? They're different corporate entities, but the same people.
Well, they're different corporate entities within a group, yes.
Yes. Isn't that part of the relevant background?
Well, it's a part of the relevant background, but it doesn't give an answer to whether the owners are entitled to direct one of those parties to repudiate a charter as against one of the others. I mean, the difficulty with the judge's analysis is that it involves essentially disregarding the terms of the sub-charters. The parties have put in place an elaborate scheme with charter parties with elaborate rights and liabilities, including clearly defined rights of termination. And then you say, but essentially, those rights are irrelevant within the wider structure because the owners can direct redelivery regardless of what the rights are under the sub-charter and the sub-sub-charter. And we say that's not an attractive conclusion. It involves really treating these agreements as as essentially largely ineffective or irrelevant, which doesn't seem to be a likely conclusion.
Right.
But focusing on the back-to-back nature, again, back-to-back doesn't really take you anywhere because back-to-back has to involve an acknowledgement that each of the charters has its own termination regime. And then you get back to the fact, well, can you require someone to operate that regime in a way that would be repudiatory? As to which the usual answer would be no. The second issue is the relevance of clause 10.4.5, which is pages 142 to 143 of the clauses. The essential point about clause 10.4.5 is that it does recognise the fact that there may be circumstances where termination or withdrawal could subsequently be adjudged to have constituted a wrongful repudiation. And it says that, and this is top of page 143, if such termination or withdrawal occurs after the permission of the owner is given, then the owner isn't responsible. The judge interpreted permission as including instruction. And we say that that is not the correct construction, that it's more likely that permission is to be contrasted with instruction, in the sense that you can have a situation where the owner says to the sub-charterer, let's say, you can terminate the sub-charterer if you want to, but upon your own head be it. And in that situation, it makes sense for the owner not to have any liability. And this is all against the background of the fact that unless the owners do give permission, the sub-charterers wouldn't be entitled to take any step in relation to terminating the charter or prejudicing rights under the charter in any way. So you start off with the owners being in control. The owners can relax that control, in which case, if the sub-charterers in this case take advantage of it, they should bear the consequences. But that doesn't deal with the question of an instruction. And logically, you would expect an instruction to attract different consequences from permission. And that takes us back to the point that you wouldn't expect somebody to be able to instruct somebody to repudiate another charter. So that's the argument on the first limb. Then, as an overarching point on grounds 1 and 2, the owners say in paragraph 16 of their skeleton that this is an unlikely structure because the sub-charterers could always retain possession of the vessels, notwithstanding the termination of the head charters. In response to that, we say, well, the owners agreed to the sub-charterers having possession of the vessels on the terms of the sub-charters, and so it's logical that they should only be able to dispossess these sub-charterers in accordance with the terms of the relevant sub-charters. Ground 3 is relief from forfeiture. And in relation to relief from forfeiture, there were two issues, jurisdiction and exercise of discretion. And in relation to jurisdiction, the judge followed the course of the arbitrators in proceeding on the basis that there could be jurisdiction and deciding as the case on the basis of discretion. It's not seriously contended by the owners, as we understand it, that there isn't an arguable case that there's jurisdiction. The only point the owners take in the skeleton is that they say that relief of the sort that is requested by the appellants would, as they say, paragraph 19, quoting the judge, be unlikely to be ordered whatever view is taken as to the grant of relief. And we say that that goes too far. Essentially, the form of relief that we're asking for, the interposition of or instatement of a new charter, is simply the granting of relief from forfeiture on terms, which is something the Court of Chancery has done for hundreds of years, and has done in the analogous situation of head leases and sublessees, where the practice has been to grant relief, where the lease has fallen away, to grant relief on terms that a new lease would be put in place.
You say it's all been done for hundreds of years. Mr. Lieberter says it's never been done in any case in English legal history, which might be dangling a bit of a temptation before any judge.
Yes,
quite. I don't think he means it that way.
Yes.
But well, I think we ought to proceed on the basis that the judge did.
Yes.
Really.
So the real issue is the exercise of discretion, and really this is a short point in relation to the way that the judge decided it, which is that essentially, by the end of the judge's reasoning, he'd come to the position that there was one point and one point only that mattered, and that was the terms of the parties' agreement. We see that in paragraph 146 on page 94. He says, starting from the position that he was being asked to consider arguments of disproportionality as between the change of control and the consequences for the parties in terms of the loss of possession of the vessel and so on. He says the owners do not have to justify the term or its effects. And then a few lines down, it was what they agreed. The proportionality of the result has to be measured against what they agreed would be the result. An argument the owners are actually better off because the cash injection into the group does not change the position. And then he goes on to say considerations of commercial certainty are very important. So essentially there, he said, well, what the parties have agreed is so paramount that no disproportionality can justify relief from forfeiture being granted. Now, if that were the right approach, then relief from forfeiture would never be granted, because relief is always being granted in circumstances where the parties have agreed that there should be a forfeiture in the circumstances which have happened. And the question before the court is whether there should be relief from that forfeiture because of the considerations which courts have taken into account over the years. So essentially, the reasoning in paragraph 146 treats the parties' agreement as a trump card and indeed as inviolable. And we say that is simply to place too much weight on what the parties have agreed. We've always accepted that the agreement and commercial considerations are something to be weighed in the balance, but what we've equally always said is that it cannot be a trump card. So that's where we say that the judge went wrong in terms of the exercise of discretion. Then as to whether there is a prospect that a different court could reach a different view, this is a very stark case in terms of the disproportionality, comparing what's happened in terms of the change of control event with the consequences for the parties. And we say there is a very real prospect that a different court could reach a different view if the considerations were weighed in the balance as they should be.
So how does this work? Because the arbitrators have already decided in a way which binds the parties to the head charter that there should not be relief against forfeiture.
Yes.
So are you saying that the court can override that so far as the head charter is concerned?
It's not it wouldn't be overriding it because it's a different question. In the head charter context, the tribunal was only concerned with the rights as between the owners and the charterers, and the charterers were in fact never in possession of the vessels anyway because of the subcharter and the sub-subcharter. So it was a different question. The question here is the dispossession of the right, particularly of the sub-subcharterers. That's an independent possessory right, which arises through the bailment of the vessels to them,
but it's relief against forfeiture, which takes the form of reinstating a contract. But according to the arbitrators, the contract is gone.
Well, in stating a different contract between different parties, because this would be a contract in the simplest version between the sub-subcharterers and the owners, the charterers wouldn't play any part in that contractual chain.
Yeah. What about the charter guarantee? Guarantor, rather.
Well, that's not something which has been raised by the owners. It's something that could have been raised by the owners.
Yeah, but I mean, it's quite an important feature of this arrangement that there is a charter guarantee.
Yes.
Which presumably guarantees, I haven't looked at it in any detail, but presumably guarantees performance under the head charter.
There are guarantees in relation to each layer of the charter, but yes, in principle, your lordship's right.
You'd need to renegotiate that somehow.
There's nothing precluding the court from imposing terms as to the grant of relief. That's not a term that the owners have sought so far, but it's not something that's outside the court's power to deal with if it needed to be dealt with.
Yeah. Right.
Essentially, what the cases show is that this court's jurisdiction is extremely flexible. The court can impose terms, and then there's really not any conceptual limit to the terms that might be imposed. Finally, indemnity. This can be dealt with rather shortly. It only arises in a relatively limited situation, as I've said. But if it does arise, it's Hornbook law that an indemnity should be implied against a party being required to comply with another party's instructions. Indeed, in the Island Archon, that was said to be an implication of law rather than an implication of fact. So we say that there must at least be a real prospect that another court could find that there was an indemnity. And in any event, it's not entirely clear on what basis the judge decided this point. The judgment was rather laconic. It may be that it was on the basis that there was automatic termination, in which case, of course, the question of implying an indemnity doesn't arise. And so, to some extent, we don't have the benefit of a detailed consideration of the arguments in the event that there isn't automatic termination.
Yes. Right.
So, my lord, that was all I was going to say on permission to appeal. I probably said too much, but
no, it's all been very helpful. Very much. Yes.
I anticipate you wish to hear from my learned friend.
Well, actually, I don't.
Well, you might not.
Actually, I don't. Thank you very much. I'll give judgment. This is an application for permission to appeal from the judgment and order of Sir William Blair. The hearing below was expedited in view of the urgency of the situation. The urgency being that the owners say they are entitled to redelivery of 2 vessels, while the chartering group disputes that. It was therefore similarly urgent that the application for permission to appeal should be dealt with expeditiously. I therefore directed that there be an oral hearing of the application so that not only the question of permission but the questions of any consequential directions as to stay or conditions could also be dealt with. I'm grateful to the parties for their clear submissions, which have clarified the matter in my mind and enabled me to reach a firm view that permission to appeal should be refused. It is unnecessary to set out the facts of the case, which are all clearly explained in the judgment of Sir William Blair. There are 4 proposed grounds of appeal. The first is that the sub and sub charter parties terminated automatically as a result of the termination of the head charter party. The second is that if that was not the case, there was nevertheless an obligation on the charterers and sub-charterers to terminate the charter parties in their capacity as owners down the line. The third is that there should be relief from forfeiture, these being bareboat charter parties, where a right to possession is conferred. The fourth is that the chartering parties were entitled to an indemnity for liability incurred as a result of termination of the charter parties. The judge decided that the sub and sub-sub charter parties were automatically terminated. He said that whether that was the position ultimately depended on the contractual arrangements between the parties, which must be right, and concluded that the arrangements here were such that there was automatic termination down the line. It seems to me that he was very probably right about that, but that the stronger and, in my judgment, beyond argument way of putting the case is that there was an obligation on the charterers and sub-charterers to terminate their charter parties as a result of the events which occurred. And therefore, that the critical question is whether the charterers have a real prospect of success on ground 2 of their proposed appeal. As to this, the scheme of the parties' arrangements seems to me to be clear. There was a termination event under each of the charter parties as a result of the events which occurred, namely a reduction in the shareholdings of the relevant parties when a third party, MSC, acquired its shareholding. The owners made clear that as a result of that termination event, they elected to terminate the head charter and they called upon the charterers to redeliver the vessel as they were entitled to do and as the arbitrators appointed under the head charter have decided. It seems to me to be clear that the charterers thereupon came under an obligation as a result of the parties' contractual arrangements consisting of not only the individual charter parties but also the multipartite agreement to exercise their right to terminate the subcharter and so on down the line. It is said that by Mr. Collett, who has explained the way in which the issues all fit together with great clarity, that that would not be the case if the result of exercising a right to terminate down the line would be to put the charterers in breach of the subcharter or to put the subcharterers in breach of the sub-charter party. He submits that because of delay in the exercise of those rights down the line, the charterers and sub-charterers had lost their right to terminate under the sub and sub-sub charter party. The judge made a finding about that at paragraph 124. He said that, quote, the reality of the position was plain, As the owners put it, it is unrealistic to submit that they have lost the right to terminate, either by effluxion of time or election, in circumstances where the sub-charterers and sub-subcharterers were being repeatedly told the vessels had to be redelivered. Any acceptance of hire does not alter that conclusion on these facts. Close quote. That is a finding of fact which this court would not be prepared to, with which this court would not be prepared to interfere. Mr. Collett submits that the judge was asking the wrong question because the charterers and subcharterers knew at an earlier stage than the owners did that there was a termination event which gave rise to a right to terminate. He submits, therefore, he submits also that the judge's conclusion ignores the fact that the charterers and subcharterers had no wish to terminate their charter parties, and that it is their conduct which must be considered. In the circumstances of this case, where all of the chartering group were related companies, run, no doubt, by the same individuals, that seems to me, with respect, to be somewhat unreal. As the judge said, the reality of the position was indeed plain. It seems to me, therefore, that ground 2 of the appeal has no real prospect of success. So far as relief against forfeiture is concerned, the judge, which is ground 3, the judge was prepared to assume that there was jurisdiction to grant relief in the circumstances of this case, notwithstanding that, as Mr. Lebetter, for the owners, points out, there is apparently no recorded case where relief against forfeiture has been given in the case of a bareboat charter party. But making that assumption, the judge refused relief as a matter of discretion. He took account of the matters on which the chartering companies relied, in particular what were said to be the disproportionate effects on them of losing the benefit of these charter parties. But he agreed with the view of the arbitrators under the head charter that, quote, these are international transactions between commercial parties, and it was what they agreed. The proportionality of the result has to be measured against what they agreed would be the result. An argument that the owners are actually better off because of the cash injection into the group does not change the position. As the arbitral tribunal put it, and this is a quote within the quote, these are bespoke commercial contracts negotiated between sophisticated counterparties advised by lawyers. Considerations of commercial certainty are very important, and the case law demonstrates that relief from forfeiture is rarely granted in bespoke contracts negotiated between experienced commercial counterparties. That's the closure of the internal quote. That was the tribunal's view, and I agree with it. Close quote. Mr. Collins admits that that puts too much weight on one particular factor, and that if that position were adopted, then relief against forfeiture could never be given. But the weight to be given to such factors in an exercise of discretion is a matter for the judge. There are further difficulties which would arise in any attempt to grant relief against forfeiture. The head charter party has been terminated. That is the ruling of the arbitrators, and it seems to me that the court cannot interfere with that. What would have to be done, as I understood Mr. Collett to accept, is to create a new contract effectively between the owners and the sub-charterers so that they could retain possession of the vessel. there would also no doubt need to be some renegotiation or rewording of the charter guarantee so that it applied in the circumstances of that new contract. It seems to me that all those sorts of consideration more than justify the conclusion which the judge reached, and that there is no real prospect that this court would reach a different view. As I understand it, in those circumstances, the claim for an indemnity does not arise, but even if that were to be the case, I can see no circumstances in which it would succeed. Accordingly, with gratitude for the parties' submissions, I refuse permission to appeal. Right.
My Lord, I'm grateful. I'm sure that Mr. Corris and I can agree a suitable order that arises from that, if that would be of assistance.
Yes, well, it will just have to say permission to appeal is refused.
Yes, and indeed that the stay obviously doesn't continue.
Yes, well, yes. It was quite clear that the stay ran until judgment, which has now been given.
Indeed.
And I think the deadline for redelivery is 4 p.m. London time today.
Yes.
Yes. All right.
And my Lord has indicated that should be that they should have taken steps to do that. My Lord, we also seek our costs, but I've actually asked Mr. Jones if he would deal with that.
Yes.
My Lord, very briefly, we ask for our costs of resisting both the stay application and also the application for permission to appeal.
Yes. I mean, we don't normally give costs to a respondent. Why should we in this case?
Indeed, that reflects the practice direction. The normal rule is not to grant a respondent costs. That is subject to an exception, my Lord, which you'll be familiar with, which is where the court directs a respondent to file submissions or attend a hearing. Now, my Lord permitted us to file submissions, which I hope were helpful to the court, and we were given notice of this hearing, so we do say we fall within that exception, paragraph 22, but my Lord should nevertheless exercise your discretion to grant us costs in view of both the weakness of this appeal and we hope the help the court has had from our written note which we filed yesterday. That is all I want to say about the permission to appeal application. We do say that in any event we should have our costs of resisting the stay application, which was an important application from our client's perspective with quite serious consequences. Now that required us to file a fairly detailed statement of Mr. Gibbons, which the court may have seen in the file,
yes,
responding to the applicant's statement, and that required some considerable time and also preparation for this hearing in relation to that element. So if my Lord isn't with us on the first limb, you like the permission to appeal element, we say that in any event we should have our costs, or some degree of our costs, to reflect the work done on the stay application.
Yes.
That's all I had to say on the principle of costs. We have a statement of costs for summary assessment, if that's found its way to the court.
Yes, I've got that. Was that the one with the grand total of £49,000?
Yes, indeed.
Yes.
And you can see from that, in particular, the work done documents on the final page.
Yes.
Split into two categories. One is dealing with the application for permission to appeal and the stay application, which is put together, and the other is the estimated costs for attending this hearing. So, my Lord, our primary position is we should have those costs summarily assessed by Lordship now, yes, if not a proportion of them reflecting the work that was done on the stay application.
Yes, all right, thank you very much. Colin?
My Lord, firstly, as to whether costs are available in relation to the respondents, they were clearly not directed to attend or to file a document. They asked for permission to do so and they were given that permission, and so they're not within the exception to the rule. So in relation to permission to appeal, the general rule should apply, and in a sense that's reinforced by my learned friend saying this was a very weak appeal. Well, if it was so weak, why is it necessary to put in so much by way of documentation. Now, without accepting the point in relation to the stay, I can see that that might engage different principles, because that was a separate application which was responded to separately, albeit in a sense unsuccessfully in relation to holding the ring up to the date of this hearing. So in that sense, although the evidence was put in, it didn't affect the outcome in relation to the interim period. Whilst I'm not accepting that the court should award costs, I can see that it falls into the discretionary area rather than the bright line rule. As to the amount of the costs, though, the difficulty is that this schedule, firstly, doesn't distinguish between three different applications, or three different matters. You've got the permission to appeal, you've got the response to the stay, and then you've got the owner's own cross application for conditions to be imposed in relation to permission if it were granted. And that application, if I may say so, was an extremely ambitious one that sought conditions including payment of all the termination sums that have been awarded by the first award in the arbitration. It sought security for costs, effectively costs in the arbitration, trying to do exactly what the authorities say you shouldn't do by way of conditions, which is to get enforcement through the back door, as opposed to focusing on protecting the particular prejudice that might result from permission to appeal having been given, as to which there might have been more justification. So there are those three matters mixed up together: permission to appeal, where costs would not normally be given; stay, which is a grey area; and then the conditions, which, whilst in theory might have been a legitimate application, was in fact way too ambitious. And against that background, you then have the difficulty that these costs are manifestly excessive and disproportionate. Taking a step back, there is no way that a figure of £49,000 can be in any sense justified for an application of the simplicity of today's application. The reasons why the figures have become so high are partly explained by the number of fee earners that have been involved. So we see 4 fee earners plus a trainee are involved. We then see, in relation to the work on documents, a great deal of duplication. So in relation, there's not very much specificity in relation to the schedule of work at the back of the cost schedule. But we see, in relation to item 1, we see 3 different fee earners spending cumulatively more than 4 working days on those stages. And it's very difficult to see how that can be in any sense proportionate, and how there can't have been a very large degree of duplication there. And then in relation to the costs of attending the hearing, 4 fee earners are allowed for appearing at the hearing. That's clearly not justifiable. And then in terms of counsel's fees, the brief fees cumulatively are over £20,000, which again, for an application where the only issue is permission to appeal, which has already been argued once in front of Sir William Blair, and which deals with matters which have now been argued several times over by the same council team, is not, I would have to say, a realistic figure. So whether one looks at it as a matter of assessment or as a matter of principle, we say there's no justification for making a monetary costs award today. The most that could be said was that some small part of these costs might be ordered to be assessed, but in my submission, a more just order would be not to make any orders to costs.
Yes, thank you very much. Well, Mr. Jones, I'm minded to award costs, but to knock a bit off for the usual reasons. You can have a go at persuading me not to if you want to, but I'll leave that up to you.
No, my lord. I'll leave it at
Well, it seems to me that although the respondents were not directed to attend or make submissions, it was reasonable and helpful for them to have done so, and also to attend to deal with the issue of stay, and for for in the somewhat unusual circumstance of this case, it seems to me appropriate to award the owners their costs of these applications. I would accept Mr. Collett's submission that the application for conditions, in the event that permission to appeal had been granted, was somewhat ambitious, but I think I might very well, if I had granted permission, have made some conditions, imposed some conditions on that grant. I propose, in the circumstances where the grand total claimed is some £49,000, to take account of that factor, the points made by Mr. Collett, and the more or less inevitability that if the matter went to detailed assessment, some reduction would be made by awarding costs in the sum of £40,000. Right, if you would submit an order, that would be very helpful. That, I take it, concludes everything. Thank you very much.